Welcome back. Well, I'm sure we're all familiar with the story. The EC declared the 2012 presidential election in favor of President John Mahama and the NDC. Now, this declaration is being contested in the Supreme Court by Nana Addo Dankwa Akufo-Addo, Dr. Muhammadu Bawumia, and Jake Obechebi Lamte. The Supreme Court is the highest court in the land, and Ghanaians and the rest of the world, of course, are very interested in the verdict. Yesterday, we telecast live some of the proceedings and some of the legal jargon, the terminologies and the reasons for this and that seem to be confusing many people. Many newspapers, many news organizations, if not all, have covered this extensively and focused on it. But how well do we understand what is actually going on, what its implications are, and what the meanings to those terms are? For example, what is an affidavit? Why is it called an affidavit? And so on and so forth. What are the rights of the different parties? What is due process? How long is it all going to take? How long can it possibly take? To help me perhaps better understand this, I've got Dr. Maxwell Opoku-Agyemang with me in the studio, and you're welcome to participate in my conversation by posting your questions to the TV3 Sunrise page on Facebook. So you have any questions at all regarding the proceedings, not the case itself, but how it is evaluated or how it takes place in the Supreme Court, who does what, why, for how long, and so on and so forth. Don't hesitate, just post it, and I'll try to include it in the conversation. Good morning and welcome to Sunrise once again, sir. I hope I'm not going to get into any kind of legal trouble for talking about a case that's before the Supreme Court.
Well, it depends. It depends. You see, a case like this being told live, there's a danger inherent in the way some people handle it. But it's good that you have cautioned yourself with this first question. You have cautioned yourself because you can report on cases, you can comment on cases, but you cannot scandalize the court. How do you scandalize the court? That is what we have to be very careful. Let me just give you an example. A lawyer says that petitioners have a burden of proof. You can talk about it. If you don't understand, you find out what it is. But if you want to get into trouble, then you start saying what the lawyer said, and even the responses of the judge. You could see that the judges and the lawyer, they don't know anything. In fact, some of them were even sleeping. The judges were looking somewhere. It seems they are not interested in this party's case. When he's talking, he's looking through out the window. All these are scandalizing the court. You see, matters like this, if you don't take care, you'll be held before the court for contempt. So you have to limit yourself to what is going on.
Okay, explain to me what is going on, because the terminology that emerges and the back and forth confuses me, and I'm sure many of our viewers.
Well, what is going on is simply the beginning of a trial. You know, the paperwork is supposed to have been completed. The lawyers will say normally we call them the pleadings, where the back and forth paperwork. And don't forget, the Supreme Court has different jurisdictions. It sits as an appellate court. That is most of the work it does. It can review its own decisions sometimes. Then in this particular instance, it's sitting as a court of original jurisdiction, which means the case is starting from the Supreme Court. Normally, cases will go to the Supreme Court having traveled through the system, maybe from Circuit, High Court, Court of Appeal, then they will end up at the Supreme Court being the highest court. That is when it's sitting as an appellate court. Sometimes it sits as a review court, which means its own decisions. You want to review its own decisions. But instances like a presidential election, it sits as a court of first instance. So because of that, sometimes you don't seem to understand what is going on. Because if it's on appeal, mostly we don't go there with evidence and oral. We go there with the records of proceedings from the Court of Appeal. You file it with your grounds of appeal, and then they will look at the documents and then come out. If need be, they may call you for not much of advocacy at that place. But when it is a court of first instance, where it is starting, you see, that is where, but they have decided to adopt their own rules, where there's a hybrid position now. They decided to go with both affidavit, which is written documents submitted to it, and then they also give a window of opportunity that some parties will be allowed to give viva voce or voice evidence or oral testimony. So that is what is going on. That's why they insist that certain documents should be filed. If it has been truly an appeal, they will base their decision only on the documents submitted. If you fail to submit, then you may lose your case. But this one, there's a combination. So they allow you to file. You have to file your documents. Interrogatories have been filed. Further and better particulars, file them so that they have all the documents. In most instances, they can base their decision on documents filed. But they said they will allow evidence to be taken in court because it's a court of first instance. So they are obliged to do that, to hear the parties, to speak to the documents, to explain issues, to be cross-examined so that they are clear in their mind. So that is what is going to happen. So what happened was that it seems all the documentations were not ready. The petitioners have concluded yes, and they wanted others to respond. See, your response is either to deny or to affirm or to supply your own evidence. Of course, it is true that the petitioners who have gone to court bear the burden of proof. But we also know that at least all the others also have the evidential burden. The evidential burden is to supply evidence contrary to what your opponent has supplied. If you fail, it means you have nothing to say. But maybe, I don't know what the strategy of the other lawyers will be. Maybe they want to wait and their addresses respond. But I think the Supreme Court did not allow it and insisted that no, as we ordered, submit your documents, submit the summary of your evidence in response to what the petitioners have done, and then from that onwards, then we move on. We move on to maybe when we start, the documents itself cannot speak. So human beings will speak to the documents and explain. That is where, when you are in the way of explaining, you may make certain statements, and you may be cross-examined on your documents. So that is what has started. And let's hope maybe today all the processes will have been completed. Then we can start the other part, from the documentary part now to the actual hearing, where we will see human beings, not papers, human beings speaking to those they have submitted, for others to have the opportunity to ask questions. That is what we call cross-examination. That is what is going to happen.
How long could all this possibly take? What's the shortest period and what's the longest period in your estimation?
Well, I was telling my students yesterday that, in fact, I may have a legal knowledge, but I have not matured to legal prophecy. I have not reached that stage yet. I cannot. You see, because in battles like this, it's not always straightforward. Maybe you thought yesterday they will start, and then it will continue. Then what happened? Something crop up, Agyemang. You see, they will resume. But I think that with the way people are concerned, as I believe you are concerned with about how long it will take, and I think people are talking about it. I believe that we should give us the inclination to look at our system, and maybe you can lead the crusade and change. You see, because it will stay long if there's a motivation by a party to delay. If there's no motivation of a party to delay, it will be very fast. So the question is, do you have a party who want to delay, and do you want a party who want to be very fast? The reason I'm saying this, people make reference to Kenya. Kenya, they changed their law in such a way that when after the election, you do not inaugurate the winner to start acting as the president, but rather remain as president-elect. If in such a situation, nobody is occupying or nobody is benefiting, so the petitioner will want the petition to go on. The respondent also want it to be concluded, because none of them is occupying the position. But we have an incongruous situation in Ghana, where the way our system is, you inaugurate. when you inaugurate, the person, one is benefiting because one is the president, the other is not. And if the other is not, the motivation for one side maybe to maintain the status quo, because after all, I am in office. And then the eagerness of the other party, that is where the problem comes in. That's where the tension builds up. So that was why Kenya, they amended the constitution immediately after the civil strife. Sierra Leone, they amended it immediately after the civil strife. Maybe Ghana, we are lucky, we have not gone through civil strife. But having learned these lessons, maybe that is the way to go. So that when that happens, you and I will not be sitting here talking about delays, because nobody will be interested in a delay, because you are not president, I am not. Whoever wins the case will then become what? The president. But now, whether if one is already in charge. So that is, if we want to talk about a delay, I think we must look at from that perspective. Then later, maybe not at this time because it's already in court. Maybe later we may be able to change our system. But I hope the Supreme Court, the way I see it, they have given the indication and they are following it, that they will sit every day, including holidays, which is something which never happened, which means they also are eager to let this matter be concluded. So I hope it won't take very long, but to put a time frame on it, I do not intend to do that, because maybe you call me and say you give us 1 week, and 1 week we are still on. Let us go through the processes very fast, but not as fast as to defeat due process. Not as very fast to defeat due process.
This is a really important case. It's a landmark case. It's a case that has got a lot of public attention and media focused on it. The Supreme Court opened itself up to the media yesterday. How important is it, in your opinion, for viewers, for the general public, to understand what is going on and understand, for example, some of the terms that are emerging, like an affidavit? What is an affidavit?
As for the terms, just watching it, you not understand, because they won't give you explanatory notes under the screen that you understand. That's the most important thing, that you call people who have that knowledge to explain to you. Definitely, no matter what, even though most of the thing will be English, but sometimes even the English word, we call it has assumed a term of art. So you may think it's normal English, but the understanding is different.
How would you explain affidavit in normal English to what you would consider a normal and non-legal person? Why is it? What's an affidavit, and what's so special about it?
Well, it's not. You see, it's because of this case. Because people have been going to commission for vote every day to prepare an affidavit. It is. You see, you swear to words that you believe in on paper. So you swear an oath, you seal it. So what I want to say, when I'm asked to prepare an affidavit, what I have to say, I go and put it on a paper. But that paper should be sworn to. Sworn to, which means you swear that what you are saying there is the truth and nothing but the truth. In the same way, when you go to court and you are going to give oral testimony, you swear. So those words that you are going to swear to in court and give it orally is what you are going to put on paper. That is affidavit. And so it is a statement of your testimony put on paper, sworn to by you before either a commissioner for oath, a notary public, or a judicial officer. That's it. It's nothing. It's nothing. Any document that you want to use in any judicial process, and they say swear to. When you go to an embassy, you swear an affidavit. When you go to an embassy, you swear an affidavit. That's why you say whatever I say true, right? Because if it turns out to be false, the consequence that you have perjured yourself, you may go to prison for perjury. In the same manner, if you go to court and you swear, see, it's oral, but it's something the same. If you put it on paper, what you are swearing to in court, we call it an affidavit. If you stand before the judge and make the same, it's the same statement. the same statement. So when the judge asks you, what the judge is telling you that what you want to tell me in court here, maybe because of this problem, I may not be able to listen. But then, put everything on paper so that by the time you come here, we will look at it and see how relevant it is. And if need be, we will cross-examine you on the statement. That is an affidavit. It's not a mystery. It's nothing. It's just paper. A paper that you put on. Go to right now, you can go to a commission for it and swear. You want to change your name, you swear an affidavit. You see, whatever you want to do, which has a legal consequence, you swear an affidavit.
Okay. Well, I'm discussing the legal proceedings and the due legal process that we see and witness going on at the Supreme Court. It's a really important case, a landmark case. I'm talking to Dr. Maxwell, lawyer Maxwell Opoku-Agyemang. And if you have any questions to add to mine, please share them with me and with him via the TV3 Sunrise page on Facebook. When we talk about court proceedings, you said earlier on that the proceedings of the Supreme Court are in some ways different from proceedings of other courts. What is the significant difference?
Well, as I said, the Supreme Court is the highest court. And sometimes they don't only even use law. They combine all, because, you see, law at that end may be a combination of social, political, economic, and then the law itself. But when you go to the lower courts, strictly you apply the law, and most of them you strictly apply the law. But when it comes to the Supreme Court, because their decisions will have far-reaching ramifications, they take a lot of other things into consideration when they come out. And as I said, when you even the processes of going there, see, even though it may be the same, but they have different names. So when if you are going to a high court, to say you file a statement of claim. When you are going to Supreme Court, you say you file a statement of case. You see, but almost in the same measure. But as I said, mostly the Supreme Court sits as an appellate court. And as an appellate court, they are going to review decisions from a lower court. So normally what you do is that you present the records of proceedings from the lower courts. And then when it is sitting on an appeal, they don't deal with factual situations. They don't deal with the facts. The facts are dealt with by the trial court. The trial court will deal with the facts. It's a trial court that look at the faces of witnesses, how they behave, because the trial court will take all these things into consideration. And when it comes to factual, mostly the Supreme Court will defer to the decision of the trial court, because they have the opportunity in seeing the people. In Supreme Court, you may not go with all the witnesses, because the witnesses have already dealt with. Supreme Court, you are going to deal with errors in the law. Maybe they erred in law, not maybe they didn't call this witness. You can't do that. So that makes it a little bit different. And there you are going to advance the legal issues. Maybe the judge misdirected himself in the explanation or in considering these legal terms. It did not construct it in a way that, so that is what you are going to do. There you are not going to have witnesses mostly lining up, but rather they are going to deal with legal issues. It's different from, but as I said, when you have a Supreme Court sitting as a court of first instance, that is where they have to come out with their rules. So they came out with their rules to deal with this matter. And therefore now they said they will go by affidavit, but they will also listing, which means at least as a court of first instance, they will give opportunity for witnesses in person to appear.
So they will look at the facts of the case, they will look at evidence,
yes,
and they will compare that to the affidavits, and yes, they will also listen to witnesses,
yes, and
they will even allow PowerPoint presentations.
Well, I don't know whether they will allow it for now, because at the first, April 2nd, I think it came up. I think some of them said they were not ICT savvy and things like that, and there, some also said they don't have the equipment and the gadgets. Maybe as time goes on, maybe when they realize that PowerPoint is not a monster, but because it's normal, because they all have the computer and therefore it can easily be done, maybe. But for now, but I believe the petitioners have apart from the soft copy, has also printed the PowerPoint presentation, and I think they've also given them the disc, the CD, to insert in their own computers. So maybe they may not have a general PowerPoint presentation on screen at the court. But I believe we are getting there. First and foremost, we have allowed TV cameras. It's an innovation. So we are now dealing with technology as well. Who knows? The time may come, the Supreme Court will have its own YouTube to beam this thing live. So we are getting somewhere. You see, we are getting somewhere. As time goes on, we are adding technology to our system. So I'm hopeful that a time may come where some of these, because in some of the high courts, I remember even in the quality grain trial, PowerPoint presentations were used as far back as 2002 were used. So it's not something new. And I also know that the computerization system led by now retired Justice Brobe, very forceful in introducing, and after all, the Supreme Court has decided that fast track, which is computerized court, is something which is accepted. The decision, the Supreme Court decision has affirmed in a review, has affirmed the use of these computers. That's why we now have our fast track court. So it's not that we are averse to technology, but maybe the way and manner maybe it will be done. That's why some prefer the old conservative way, because the devil you know is better than the angel you don't know. So maybe, but I hope with the TV coming on board, I think that it will not be long that some of these things will also be used in in other jurisdictions.
And viewers are echoing some of the things that you've touched on already. Asante Kofi Akocha says, when are we hearing the final court petition? And he's writing to us from KNUST. Ado Adokwe says, how does the layman understand what is going on with all this big English? Briefly, what is going on in court to the layperson? Laji Alote says, I would like to know the possible time period the case may take. Lawrence Ududapa says, Eric, please tell lawyer that we are the largest place in Kuma with all ears. We'd like his explanations to the court proceedings. Michael also says, please, is there any sanction or are there any sanctions for delaying court proceedings? For example, delaying the filing of affidavits and so on and so forth.
Well, there are sanctions. There are sanctions when attempt undue delay is different from undue delay. Sometimes certain delays you cannot avoid. You cannot avoid. Like yesterday, the petitioners insisting that the case should be adjourned for them to be properly served. You may say that it's a delay, but it is not an undue delay. But if you attempt to abuse the process, the system have a way of dealing with you. And I believe that the Supreme Court, they know how important this case is. And therefore, if you attempt to delay, because if you look at our Evidence Act, some evidence may be relevant and even vital. But if its admissibility, you say, I'm waiting, I'm expecting, if that will cause undue delay, the court may proceed. After all, as I said, yes, the burden of proof is on the petitioner. But after all, there's an evidential burden also on the respondent to respond to what the petitioner is saying. How do you respond? You respond with your own evidence. Even though I know that you cannot win your case based on the weakness of the defendant's case. You may build your own case. But if your case is also very weak, on the scale of probability, you may lose. So, if you are attempting to delay, you make delay in such a way that then you may not have opportunity to present your case. If you do that, you may lose. So it is not in anybody's interest when it comes to providing certain information to the court and say, I am delaying. If you delay and the court said, well, we have waited for long, the case cannot wait to eternity, therefore we are proceeding. If they proceed without your case, what happens? You lose. So the utmost sanction is that if you cause undue delay and therefore fail to deliver your documents, you are hurting your client. You are hurting your client. So therefore, by that conduct, you may not have the opportunity to respond, because the court will say, we have waited, and therefore now we are not waiting any longer. If what you fail to present is so vital to your case, what happens? You lose. But I don't know. In the lower courts, when you call delay, costs are awarded sometimes Yeah, costs are awarded against you for delay. Sometimes, anytime you see, you wait till the last minute when the case is going on, then you file a document, knowing that some people have traveled all the way. Costs will be awarded against you. Costs will be awarded against you. That is also to serve as a motivation factor for you to act timeously. But as I said, the basic is that, is there a motivation for a party to delay? And is there a motivation for a party to pursue? That is where the matter is. And with this, maybe we need to rethink how our system works, so that, like in Kenya, you have to go on. That's what happened, because you are not on the seat yet, even though you say you are president-elect. So if the case is delaying, you are still president-elect. The old president still continue, you see. And to avoid that, that's why their system, you have to work very fast in order to get this thing out. But where you have a system where the life is going on, you get my point. Life is going on, and if life is going on, it may be in one person's interest, not for the case. I'm not saying that, but at least it's a presumption, a reasonable inference that I can make, that if you look at it, I mean, a reasonable person will know that there's a motivation for someone to delay, while the other person is very eager. That breeds tension. So to avoid it, maybe we need to rethink how our judicial system and how this constitutional provision works, and maybe adopt the style of Kenya. Now that everybody saying Kenya, maybe you look at Kenya, Sierra Leone, they have also changed their constitution. Now the same thing, elections, finish all legal matters before you move to the next step. But here, that is not our legal position. The law is you inaugurate, and then after which you can continue. If that is the best, well, we can look at it.
Well, I'm going to ask you a question about that, because I think it's very, very interesting that the same Supreme Court panel that are looking at this case were actually there during the inauguration.
Yes.
So how likely is it that they are going to, well, so to speak, say, well, we think otherwise now? But Joshua Oforo is asking a question about the language, about the legal terms, not so much the process or the proceedings, but the language that is used. And since this is a case that is of such importance to the general public, and it's actually being telecast in substantial part, what do you think about the possible use of simpler language that most people will be able to understand, rather than the highly specialized legal terms?
Well, I don't think these days we use any specialized English. We use normal English. If you listen to me, we use normal English. But even the normal English, let's face it, I mean, I've gone to learn a profession. All professions have their intricacies and certain traits. Try as I may, I will not be able to speak in then what is the lawyer in me? So definitely certain words will come up, but how you are going to solve this is where you have a panel, then some of these terms you throw them out for them to explain. I do not think that with this case everybody want to understand like a lawyer. No, there are lawyers and there are non-lawyers, and you have to accept it. See, people should accept that there are lawyers, so there are certain things I will understand, you may not understand, but that's how it's supposed to be. Then you ask me, I will explain to you. Otherwise, what is going to happen is that we have to send everyday English panel also there. So when the judges speak, they pause and you explain them in a normal, ordinary English. I think that will not be helpful. But anytime you identify any term that is, you explain. And as I said, even certain English word, you may think it's normal, but in law, you may have assumed a term of art. That is a term of art which will not be considered in an ordinary meaning, but as a legal meaning. You see, but all these things, there are lawyers who may be able to explain, because whether you like it or not, see, the lawyers are speaking, even though we know that you are also watching and listening. But don't forget, they are not adducing the case for you to judge. So why should, you see, it's good that they explain to you, but the essence of it is to seek the opinion and of the judges. And the judges will have to be able to speak in a language that the judges will understand. You want them to speak in what language? What language on the streets for the judges? No. Sometimes it's difficult to do that. So they try, they will try. They will not be able to, when you say come down, but I believe that these days we don't use where to for. These days we have stopped using where to for, where to where. We've tried to come down to as possible as we can. I believe that as I am speaking, yes, even though I'm trying my best, sometimes some of the words will come in, but you try your best to come down to the listeners and the viewers to understand. But because it is a court proceeding, it's a court proceeding, and we cannot say because it's a TV telecast, we should just change overnight our habits and say, no, then it becomes a soap opera. It's not a soap opera. It's not a soap opera. In fact, it's a serious case which is going on.
It's a very serious case.
It's a serious case, so the lawyers must use the serious word that it deserve.
It's a landmark case.
Yes,
it's telling going to set a legal precedent.
I'm telling you, Ghana in constitutional law, the foremost case that we have had is Akoto and 7 others, 1958. That's the foremost constitutional case, and I believe that this case is going to take over. That case is going to take over because, see, we have seen so many presidential petitions. In fact, we saw Bill Sin Rawlings, we saw Rawlings MPP, we saw Amidou Kufuor, we saw Metinunu and others, but it was a chicken feed. That case sometimes just a minor, but
compared to this one,
this is going to go to the root of our election system.
Talking about the root and the comparison you made between the Kenyan system and ours, considering the role that the Supreme Court judges and the Chief Justice played in the inauguration of our president, his taking the oath and so on and so forth, what do you think the chances are that, on political or perhaps, not strictly evidence merit, they will say, well, it's true, we have to revise our participation?
Well, that's why I use the term that we are facing an incongruous situation in Ghana, especially the judges and especially the Chief Justice. Because immediately the election came, a petition is filed. The Chief Justice is the head of the judiciary and administration. He will empanel the court, and sometimes he will even sit. Then you dress up. By law, it's a requirement of the law. You dress up. Go and inaugurate the person. A person who is being challenged in your court. You go and swear that person in. Then you come back and sit and go through the matter, challenging a person you are sworn in. That is an incongruous situation for a person.
Okay, now there's that big word again, incongruous.
Yes.
What is incongruous in simple Ghana broth? What does incongruous mean? Because
you see, I mean, you find yourself in catch situation. Catch situation. It's something which looks like an embarrassing. You see, it's
contradictory.
Contradictory, embarrassing. You see, but the law says you should do it.
Uncomfortable.
You definitely. You see, but uncomfortable. Maybe you say comfort and whatever. But incongruous people, incongruous.
So I think we should all buy big dictionaries.
Yes, you see, because then the matter is pending, state of the nation. By this person who's been challenged, you have to go and sit down there and listen. Then you come to court. Come and listen to argument against. So that is why I said, to avoid this situation. You see, in Kenya, after election, Kibaki's own, after election, less than 24 hours, were to inaugurate. And you saw what happened. That's why so many people were killed because of that. So to avoid that situation, they amended their rules and said, well, now this is how we are going to go. And you see, at least, even if you have not solved the problem, there has been an improvement. Sierra Leone, the same thing happened. They also change it and say, finish all matters litigation before you proceed to inaugurate. That also, then there will be a motivation to quickly go through the process and then come out. See, so maybe here we should also look at our days. 21 days after election have been declared for Kenya, 7 days. You see, all these things speeded up the process, and in doing so, the calm has been restored. Here, even though we seem to be enjoying some form of after storm, but I can tell you, there's storm under the waters, and people are looking up to the Supreme Court. And the more it goes on, the more these tensions build up. But since that is a system now, we cannot change it midstream while the case is pending. We can't. But I believe that as a nation, that is where we have to head towards. Is it possible that we can also adapt some of these things from our neighbors and from our brothers and sisters, and maybe change the process, and then we don't find this position of a Chief Justice or Supreme Court judges or trooping. All these things will be solved if we change the system. Until that time, we all find ourselves, I believe that the lawyers, when they meet, you say, you call him the president. Meanwhile, you are in court against him. And then you write, the Chief Justice will write, if they are going for their financial, they write to the president. Meanwhile, there's litigation and they are sitting. So by writing to the office of the president or using the name of the president, are they stopped from contesting? So we need to stop this thing.
There's another word, a stoppers. But we don't have very much time for that right now. Perhaps the next time you can explain the meaning of estoppels or estopped, and how that's different from estoppel, from stopping. I think every one of us needs to get a really nice, big, juicy dictionary. Which one would you recommend, lawyer?
Well, we have the
Chambers.
Black Law. You have the Black Law Dictionary. You have the Oxford Legal Dictionary. You can. But don't worry yourself. You see, the whole world, all fingers are not the same. No matter how hard you try, since you are not a learned person, you definitely fall short, and that's why we are here. I cannot take over what you do, and therefore also don't stretch your imagination too far that after this case you are also going to be the same as I am. If you try, you may find yourself either in a mental distress or some problem. So go on.
A word of caution to all the pocket lawyers. I know we have lots of coaches, and I'm sure with this case going on, we're going to have lots of lawyers popping up here and there.